why don't we begin, Mr. Cicilline, with you, and by the time you're done, hopefully Representative Roy will be here.
Thank you, Mr. Chairman. Thank you for the opportunity to testify, and I'm here to testify in strong support of the Respect for Marriage Act. I was proud to join Chairman Nadler and others in introducing this important measure and urge the committee to report it quickly to the House so we can pass it immediately. To begin, the bill corrects Congress's grievous mistake from a generation ago by repealing the so-called Defense of Marriage Act, or DOMA, a statute that enshrined discrimination against married same-sex couples into federal law. While subsequent decisions by the Supreme Court in United States versus Windsor and Obergefell versus Hodges effectively nullified DOMA, it remains officially on the books, lying in wait should the Supreme Court ever reverse course. We must get rid of it. Second, the Respect for Marriage Act clarifies the definition of marriage in federal law to ensure that for federal law purposes, valid same-sex marriages have equal status to any other valid marriages. And finally, the bill provides additional protection for marriage equality by prohibiting any person acting under color of state law from failing to give full legal effect to valid out-of-state marriages because of the sex, race, ethnicity, or national origin of either or both of the married individuals. Importantly, the bill gives the Attorney General the authority to enforce these protections and allows the harmed couple to bring a civil case against any official who violates these rights. Millions of LGBTQ+ people have married and formed families since Obergefell was decided in 2015. An estimated 2 million children are being raised by LGBTQ+ families, and kids do best when their families have the critical legal protections to care for one another. Passing the Respect for Marriage Act will guarantee these families the legal certainty they deserve. All married people, both those with kids and those without, who are building their lives together, must know that the government will respect and recognize their marriages. The American people agree that the right to same-sex marriage is settled law. According to a June 2020 Gallup poll, a record 71% of Americans support marriage equality, with majority supporting it across the political spectrum, across faiths, and in every region of the country. According to data compiled by the Public Religion Research Institute, 62% of Republicans, 77% of urban and suburban residents, and 70% of rural residents support marriage equality, as do the majorities of most religious groups. Although fundamental rights should never be based on public opinion alone, this data shows that the American people believe marriage equality is good, settled law. The Respect for Marriage Act will ensure that remains the case. The Respect for Marriage Act will protect the settled expectations of millions of Americans who have ordered their lives around the constitutional guarantee of marriage equality. To be clear, marriage equality already is the law of the land. In Obergefell and Loving versus Virginia, the key Supreme Court precedents recognizing constitutional rights to same-sex marriage and interracial marriage, respectively, are still in effect. People are worried, however, about the future, following the Supreme Court's decision in Dobbs versus Jackson Women's Health Organization, which overturned the constitutional right to abortion, and Justice Thomas's alarming and extremist concurrence. Although Justice Alito's majority opinion expressly stated that the ruling did not impact any rights other than abortion, one of the main lessons from the Dobbs decision is that we cannot afford to be complacent about the security of our fundamental rights. We must act now to further protect marriage equality. At a hearing before the Judiciary Committee last Thursday, we heard from constitutional law scholars about how the logic of Dobbs, recognizing unenumerated rights only if they are, quote, rooted in the nation's history and tradition and implicit in the concept of ordered liberty as determined by the court's current conservative majority, could be used to challenge other rights, including marriage equality. In addition, Justice Thomas in his Dobbs concurrence expressly called on the court to reconsider all of its substantive due process cases, specifically naming Obergefell as a decision that the court should overturn. Even if you trust Justice Alito's assurance in Dobbs, it is well within our power to ensure long-term stability and certainty for families. Marriage has long been a basic liberty for people, and it's rooted in the principles of equal protection. Marriage equality thankfully remains constitutionally protected, and the Respect for Marriage Act simply offers an additional measure of protection for and enforcement of the Constitution's guarantee of equality for all Americans before the law. It will help ensure that there is a federal protection for marriage equality no matter what happens in the future. I urge the committee to support this important bill and urge its immediate passage, and happy to answer any questions of the committee.
Thank you very much, Mr. Roy.
I thank the chairman. My Democratic colleagues want Americans to believe that the Supreme Court at any moment is poised to overturn the opinions in Obergefell and Loving. I cannot help but be thankful that we don't have to have a ethics inquiry because of all of the space that Justice Thomas is taking up in the heads of my Democratic colleagues. He's living rent-free and not paying for that rent, but he's certainly living in the heads of my Democratic colleagues nevertheless. He wrote a concurrence. Justice Thomas wrote a concurrence. And in that concurrence, Justice Thomas wrote, after overruling these demonstrably erroneous decisions, the question would remain whether other constitutional provisions guarantee the myriad rights that our substantive due process cases have generated. For example, we could consider whether any of the rights announced in this court's substantive due process cases are privileges or immunities of citizens of the United States protected by the 14th Amendment. In other words, he simply questioned the how. He simply questioned the how. And he did so in a concurrence. But at the same time, in the majority opinion, there are numerous specific mentions by the majority suggesting that the majority had no interest in touching those cases. In Dobbs, the court stated that Obergefell and other substantive due process precedents are, quote, inapposite to the asserted right to an abortion. And the Dobbs opinion, quote, does not undermine them in any way, unquote. Just in any case, anyone is not clear on the meaning of, quote, does not undermine them in any way. The court later reiterated that Dobbs' decision should not be, quote, misunderstood or mischaracterized to cast doubt on precedents that do not consider abortion. The court condemned the alarmist idea that Dobbs would lead to the overturning of the other cases as, quote, perhaps designed to stoke unfounded fear that our decision will imperil those other rights. And it is that unfounded fear that brings us here today. There is no threat. My colleagues are here for political messaging. We're here because it is July of an election year and we're going to be adjourning in 2 weeks. And then inflation is at a high of the last 40 years, that inflation is at 9%, that our borders are wide open and our Texans and the people across this country are exposed to wide open borders. You know, the median age of an American is about 38 years old, and that means that more than half the country wasn't even alive the last time that inflation was at the levels we currently see. And we're here because my Democratic colleagues have no answers to that, and so they want to strike fear in the American people. Unfounded fear, I would add. And I would note that my colleague from Rhode Island referenced the so-called Defense of Marriage Act. Well, that so-called Defense of Marriage Act was voted for by none other than President Joe Biden, Senator Patrick Leahy, Senator Patty Murray, Senator Dick Durbin, Senator Bob Menendez, Senator Chuck Schumer, Representative Steny Hoyer voted for the Defense of Marriage Act. Representative Ben Cardin, Representative Jim Clyburn, Representative Elijah Cummings, Representative Rosa DeLauro, Lloyd Doggett, my colleague from Texas, a host of others. I think we know why we're here. I think we recognize that we're here for political purposes. And I would note in closing, Mr. Chairman, that the rhetoric of codifying Obergefell or codifying Loving is not even true. The legislation put forward would do no such thing. The legislation put forward would force states to recognize marriages across state boundaries, which might be a laudable policy goal that we could debate. And I must side note, just thank my colleagues for recognizing the importance of the democratic process, that we're here as the people's representatives having a debate about policy rather than looking to the Supreme Court to make policy. Suddenly now that the court doesn't issue an opinion that my colleagues favor, but that it is noteworthy that the legislation put forward would not codify Obergefell and would not codify Loving in the clearly unlikely or unforeseeable case that the court were to take up a case and strike either of those down in the clear clamor for such a thing across the states, I say, obviously, with some degree of sarcasm. And I yield back.
Thank you very much, both of you, for your testimony. I don't have any other questions, except the fact that I would say that, to Mr. Roy, that I think that there are many people in this country, myself included, who are really quite concerned where the Supreme Court may go next. I think a lot of people, were kind of lulled into some sort of comfort that they wouldn't go after Roe versus Wade, based on the fact that when these justices went for their confirmation hearings, would repeatedly kind of reassure everybody that it's all settled law, that they have no intention of trying to overturn it. And yet, clearly, I guess the best thing you could say was that they were intentionally misleading people. I think they perjured themselves, quite frankly, because I think they lied. But that's me. But then all of a sudden, they basically took a right away from people in this country, and we're seeing, what that has meant. A 10-year-old girl who was raped had to go to another state with her family to be able to not be forced to carry that pregnancy to full term. I read an earlier panel. I talked about what's in the New York Times today. The miscarriages. An article today, when miscarriages collide with abortion law, some women are left bleeding and in pain by wary hospitals. We are just beginning to see the cruelty of what the Supreme Court did, by the way, against the overwhelming majority opinion in this country. And so when Clarence Thomas, who unfortunately sits on the Supreme Court, issues a concurring opinion like that, people take that as a signal for there to be more cases brought to the Supreme Court on this subject. I think that was what brings us here today. You can say that that's politics. I can say that we're trying to protect people in this country and protect their rights. But in any event, that's why I'm here today. Mr. Cole?
Thank you very much, Mr. Chairman. Mr. Roy, this